Hi, my name is Guillermo Garcia Sanchez, and I'm an associate professor of law at Texas A&M School of Law. And today I will be your guide into the second section of the arbitration portion of the course. In class, we will be covering the remaining sections of the Federal Arbitration Act, particularly those that regulate the judicial review of arbitration awards. Yet, in this video, I will focus on international commercial and investment arbitration, how they differ from domestic arbitration, how they operate in international business settings, and the current trends on the protection of foreign investments and the arbitral mechanisms available to investors. So what is international arbitration? International commercial arbitration is a mechanism to resolve disputes between two private parties and is as old as commerce itself. Companies have been doing business abroad for centuries. The search for commodities from different parts of the world, the expansion of new markets as the economies open up to commerce, and globalization generally has brought companies around the world closer together. The need to solve disputes between companies and at the same time maintain a business relationship and continue doing deals is a common element between domestic and international arbitration. It is businessmen who push for the creation of these mechanisms. Yet a difference between domestic and international arbitration is the fact that as opposed to being afraid of bringing commercial disputes to courts and having juries decide cases involving complex commercial deals as it happened in New York, international companies were afraid of finding themselves having to litigate cases in foreign jurisdictions. Few companies have the capacity to hire legal teams all over the world that know the language, the legal local judicial proceedings, and have the expertise to successfully defend their interest in every local court if a dispute were to arise with a foreign partner. Hence, international commercial arbitration offers an opportunity to bring the disputes to a neutral forum, where each party can designate an arbitrator in a neutral venue and apply the law that was previously agreed by the parties. To administer these proceedings, a selected group of international organizations have emerged. Their job is to help the parties select adequate arbitrators, provide them with known and transparent rules, help them reduce the costs involved in the proceedings, and educate new businesses into the advantages of international commercial arbitration. Take, for example, the case of InBev and Anheuser-Busch. In 2008, InBev, a Belgium-based company, merged with Anheuser-Busch, an American company. The deal violated an investment deal signed in 1993 that gave Anheuser-Busch a 50% stake in Grupo Modelo, a Mexican-based company. Grupo Modelo and its Series A shareholders filed a notice of arbitration in October 2008 under the rules of the United Nations Commission on International Trade. A month before, InBev finalized its $42 billion takeover of Anheuser-Busch. In addition to $2.2 billion in damages, Grupo Modelo sought an award barring the Anheuser-Busch entities from exercising governance and contractual rights under the investment agreement. 2 years later, the tribunal determined that the merger between InBev and Anheuser-Busch did not violate the 1983 deal and awarded no damages to Grupo Modelo. As you can see, this is a perfect example of how international commercial arbitration operates. The case involved 3 jurisdictions and inter-Atlantic commerce, but most importantly, the dispute did not prevent the parties from continuing doing businesses.
Well, Budweiser is looking to hook up south of the border, and here we have a can of Budweiser with the possible merger with the maker of Corona. This stuff. Okay, we have Mike Estelle in Atlanta, food and beverage reporter, and he joins us now. Mike, thank you very much for being there. I have in front of me a massive can of Bud, which will be popping later, and a massive can of Corona, which we also might be popping later. This could be a big deal, right?
Yeah, and it's something that's been on the radar for a while. It's AB InBev, InBev, the Belgian company that bought the maker of Budweiser, Anheuser-Busch, back in 2008. That was the biggest deal ever in the industry, $52 billion. And when they bought Anheuser-Busch, they also picked up a 50% non-controlling stake in Modelo, which is the largest brewer in Mexico and makes Corona Extra.
Corona, and it also makes Negro Modelo as well.
That's right, Pacifico and some other ones. So it's been clear for a long time that AB InBev would love to buy the rest of Modelo. The question is being whether Modelo, which is family controlled, would agree to. So today the companies confirmed that they are in discussions looking at expanding their current relationship. They said it's unclear where those discussions will go and that any sort of speculation is premature. But what people have been telling the Wall Street Journal and some other journalists over the last couple of days is that those talks are heating up, and there's a very real possibility that AB InBev will finally be able to take control of Modelo.
The deal came through, and Anheuser-Busch bought in 2012 the rest of Grupo Modelo. This case is an example of how arbitration allows international business partners to solve their disputes and maintain a healthy business relationship. What really makes the international commercial regime unique and efficient is the existence of the 1958 New York Convention. This international treaty is one of the most widely ratified covenants around the world. The most important aspect of the convention is that it assures the recognition of awards and excludes any judicial review on the merits of the arbitral award. International arbitration can also help to solve disputes between investors and foreign governments. This type of arbitral proceeding is called investor-state arbitration. Although international investments are as old as the existence of capital, the creation of a system of protection of foreign investment that was independent from diplomatic protection is a creature of the 20th century. Before the contemporary regime existed, when foreign companies were unlawfully expropriated abroad or when host governments treated them unfairly, the only recourse for the companies was to request their host states to provide them with diplomatic protection. This ended up in many occasions generating military confrontations. It was called gunboat diplomacy. The investor state would intervene militarily in less developed nations to force the local governments to pay compensations to their nationals. Such was the case of the bombardment of the port of Caracas by the United Kingdom, Germany, and Italy in 1902 after the refusal of President Cipriano Castro to pay foreign debts and damages suffered by European citizens in the Civil War, or the bombardment of Cairo by French and British forces in 1956 after President Nasser nationalized the Suez Canal. So how was the contemporary regime created? Well, the idea behind the contemporary regime was to avoid having gunboat diplomacy. So it was created to give legal security to foreign investors so that they could invest in less developed nations, and consequently, this would benefit from the flow of foreign capital. But the idea behind was also to depoliticize the system. Well, just like before, let's say we had a host state receiving foreign capital, and an exporting country, let's say the United States. The contemporary regime, what it made was to create a bilateral investment system where they would sign an international treaty. And in this treaty, both states would give rights to foreign investments. What type of rights? Well, they would receive rights to be non-discriminated, to be treated fairly and equitably, to receive full protection and security, and especially to receive just compensation in case of an expropriation. Now, why would the system be depoliticized? Well, as opposed to having diplomacy, the treaties also included arbitration proceedings. Those could be ad hoc or through an institution such as the Permanent Court of Arbitration, the International Chamber of Commerce, the UNCITRAL rules, or the International Center for the Settlement of Investment Disputes. So each time there was a dispute between the host states and the foreign investor, as opposed to going and asking the exporting capital state, they would bring the claim to arbitration. And this way, the exporting capital state would not have to be involved in the proceedings. But today, most of the cases are no longer about direct expropriations. So for example, what we see today is that many cases dealing with foreign investors have to do with new taxes to certain industries, like it happened in Ecuador with the oil industry or the tobacco industry in Uruguay, social unrest and lack of protections, like it has happened in Egypt, renegotiation of contracts with different governmental actors, as it happened in Mexico and Venezuela, higher government participation in certain sectors, like it happened also in Venezuela, or emergency economic policies like the ones taken by the Argentinian government during the crisis. New state agencies created that change policies that affect foreign investors, like it happened in Hungary when it wanted to be part of the EU. Or local authorities discriminating against foreign nationals, like it has happened in the United States regarding Canadians. Many of these cases, the investors have alleged a breach of their legitimate expectations. This is also a right given in the treaties. The investment tribunals have considered that foreign investors have legitimate expectations and those have to be respected by the host state. If the state changes the policies, then they can bring a claim against them in international tribunals. So where are all these rights regulated? As we mentioned before, most of them are in treaties, but that's not exclusively. Some of these treaties can be multilateral treaties or trade agreements such as NAFTA or the Energy Charter. As we said before, they can also be contained in bilateral investment treaties. Today there are around 2,500 in force. But also the rights could be contained in the contracts signed by states and investors. States could give their rights and access to foreign arbitral tribunals to the investors in concession agreements, for example. Also, states could give the same rights and jurisdiction to international tribunals through the laws of the state, let's say a foreign investment law passed by the state. But as we said before, the uniqueness of the system really lies in the arbitration proceeding. Because investors, for the first time in history, can bring the claims directly against the state in international forum. They don't need their host state to help them bring the claim to international tribunals. They can do it directly. And also the enforcement is different depending on the system chosen. For example, the ICSID Convention has the highest level of enforcement. And we're going to be talking more about ICSID. Why? Because ICSID today has administered around 70% of all the known international investment proceedings. Just last year, it administered 258 cases. So how does the proceeding look like? Well, it looks very similar to other arbitral proceedings. First, there is a request for arbitration, and the institution can actually refuse to register depending on the type of claims made, or whether there is a jurisdictional requirement in the contract that was not fulfilled. After the registration, then the tribunal is constituted. Just like many other cases, as we said before, most of the time each party designates one arbitrator, and between the arbitrators they have to designate the president of the tribunal. If they can't reach an agreement, then the institution can designate the president of the tribunal. Then there's a first session, a written procedure, an oral procedure, deliberations, and the award. And unique to the ICSID, there is an annulment proceeding, an interpretation proceeding, and a revision proceeding. And we're going to be talking about that. It's very limited. There are very limited grounds to annul an agreement, and they are very similar to what we saw in the FAA. What about the remedies? What can investors get out of all these procedures? Well, there are two types of remedies specified in investment treaties. The first could be a pecuniary or monetary compensation. The second one could be performance remedy, such as restitution, or the state can be ordered to comply with the contract. Now, the difference between these two remedies is that for the pecuniary and monetary compensation remedies, there's an immediate enforcement as if it was from the highest court of the state. That's actually established in the ICSID Convention. Investor doesn't need to go through an enforcement proceeding like, for example, the New York Convention. That's exactly the opposite when it comes to performance. In order to enforce such a remedy, the investor would have to go through the New York Convention for recognition by domestic courts. And that is why in only 2 of the 189 cases of ICSID, the tribunal ordered other type of remedies. They always award pecuniary compensations. This is important to be aware of, and this is partly due to the fact that investors, when they file their complaints, what they ask the tribunals to order is a monetary compensation. Many states are part of the ICSID Convention. As you can see from this graph, all the blue states are the ones that have signed and ratified the convention. And the yellow ones are the only ones that have signed it but not ratified it. By the end of 2017, ICSID counted 161 signatories to the ICSID Convention, of which 153 are contracting states to the ICSID Convention. So as you can see, most of the states that rely on foreign capital are part of the ICSID Convention. How many cases has ICSID administered? Well, as you can see, it keeps growing. Up to 2017, there were 258 cases administered. Not all of them ended up with an award, many of them ended up settled, and some of them are still pending. What was the basis of the consent to arbitrate? Well, as you can see, there's a diversity of treaties out there, as we mentioned. You have the Energy Charter, but you have bilateral trade agreements and bilateral investment treaties. Out of the 62% of the sources of consent are bilateral investment treaties. That's a very high amount if you consider that there are a lot of trade agreements out there. What about geographical distribution? As you can see, it's all over the place. So it's not only in particular developing areas, but also, for example, places like Eastern Europe or Western Europe even represent 14% of the total cases. North America is 4%. Asia, we're around 8%, and South America is around 21%. Those are numbers from last year. If we disaggregate it in countries, you can see that even United States of America has been a respondent in an ICSID arbitration case. Other interesting cases of a host of exporting capital states, for example, you have Spain, England, Italy has been respondent, Belgium. What about sectors? Well, this has been changing across the years. So, for example, in 2010, many of the cases had to do with oil, gas, and mining. So these were the renegotiation of oil and gas contracts after the spike in oil prices of 2009. But then in 2014, things started to change. Oil and gas is still an important sector, but then electricity, power, and other types of energy increased. And last year, as you can see, we have a lot of cases regarding transportation, tourism, construction, and oil and gas and mining dropped to 10%. So many of the cases, as you can imagine, are related to the broader economic changes happening in the global economy. When states change policies due to economic crises or financial crises, or there's changes of government from left to right, then the type of cases that emerge in ICSID arbitration also change. What about the annulment of awards? As you can see, only 13 annulment applications have been registered in the last year. This is not a big number if you consider the amount of cases administered. In the history of ICSID, for example, out of the 555 cases that ICSID has administered, only 17 have been actually annulled. So that's a very low amount if you consider the total amount of cases being administered. As we said before, arbitration tends to be a system where review is very limited. The awards rendered and the outcomes in annulment proceedings also have switched across the decades. From 2011 to now, there has been 134 awards rendered, and again, 17 only have been annulled. The cases administered regarding the languages, this varies. The parties can decide the type of language that is going to be used during the arbitration. As you can see, most of those have been done in English, but also Spanish has been growing, and both in the dual language Spanish and English has also been growing. The origins of the arbitrators, since the parties choose them, as you can see, most of them are from Western Europe or North America, but we have also seen cases where arbitrators are chosen from different jurisdictions like South America or Southeast Asia. And the venue of the cases. As you can see, many of the hearings have been done by telephone or video conference in order to reduce costs. But many are also done in some of the major capitals like Paris, Washington, and London. This is because Exit has offices and facilities in Paris, Washington, and London available for the parties to use. This is usually how a hearing looks like. This was one taken in Washington, D.C. in 2016. So what are the investors' positions and the state's position in most of these cases? Well, the investors in most of the cases end up either negotiating or bringing a claim after an action was brought. They can either win or lose participation in the state regarding of the cases. If they win and they do not get paid, you can try to seek the assets abroad and enforce the agreement in a different jurisdiction. So let's say you win a case against Venezuela for the renegotiation of the oil and gas contracts, and Venezuela is unwilling to pay, you can bring that award to a different jurisdiction where Venezuela has assets and try to enforce the award there. The state's position. States, when they lose a case, they can either retract their actions, they can try to negotiate a compensation, or go to arbitration. If they lose, they can pay, but keep the policy. And if they decide not to pay, they can risk their international reputations and also risk their assets abroad. Now, the regime is currently changing due to particular circumstances. And mostly it's because the traditional importers of foreign direct investments are now exporting foreign direct investment to developed nations. So it's no longer the case that European, American, Canadian, and Japanese companies are the ones bringing money into the developing countries. You actually now have Chinese, Mexican, Brazilian companies, Russian companies investing in developed nations. And the trends are rising. As you can see, the developing countries' portion of foreign investment abroad keeps rising. The share of foreign direct investment flows are actually now starting to converge. And also, after the 2009 financial crisis, many of the developed countries started enacting protectionist policies. And we see that trend very, very clear now with the current Trump administration in the United States. As we can see, now we have more restriction or regulation rising, and the liberalization and promotion of foreign capital is actually going down. You can see also this trend in the amount of bilateral investment treaty signed. It keeps going down every year. And also you have the fact that developed states have also become defendants in exit cases. The United States has been a defendant at least in 5. Canada has been a defendant at least in 5. Spain in 12. Germany in 2. France in 2. So this has forced developed nations to revise their BITs, their bilateral investment treaties. And so the bilateral investment treaties now, the tendency is to include state of emergency exceptions, for example. There's also an increase in the details regarding the rights provisions to restrict the discretion from the tribunals. And also, they've modified the qualification of what is and what is not an investment. For example, investments that do not respect human rights or the environment can actually be considered as outside of the treaty. What is true is that international arbitration has not been successful during difficult political times to force reluctant states to recognize the awards. Take, for example, the case of Russia.
Russia has been caught firing artillery across the border at Ukraine. At least that's according to these images released by the US on Sunday. It's the latest development in the geopolitical standoff, and it's against this backdrop that an international court in The Hague has ordered Russia to pay $50 billion to shareholders in Yukos, the former oil giant. Emmanuel Gaillard is a lawyer representing the shareholders.
The Russian state apparatus launched a full assault on Yukos and its beneficial owners in order to bankrupt Yukos and appropriate its assets, while at the same time removing Mr. Khodorkovsky from the political arena. Not my words, those of the tribunal.
Yukos, once run by Mikhail Khodorkovsky, was nationalized by Russia over a decade ago, and most of its $40 billion of assets handed to Rosneft. The court on Monday said officials under President Putin had manipulated the legal system to bankrupt the company. $50 billion is about 2.5% of Russia's total GDP worth, or 57% of its reserve fund, earmarked to cover budget holes. Russia has 180 days to start repayments, or interest will start to be added, according to a lawyer involved. But the ruling may not bring an end to 10 years of legal proceedings. Sergei Lavrov is Russia's foreign minister.
Court proceedings are not finished yet, and an appeal is possible. The Russian side, those agencies which represent Russia in this process, will no doubt use all available legal possibilities to defend its position.
And they did. Since the Russian government has not ratified the exit conventions, investors have had difficulties in enforcing the $50 billion award. They have unsuccessfully asked courts in the US, the Netherlands, and France to enforce the award under the New York Convention. But due to the high stakes involved in the case, and due to the fact that most of the assets belong to the Russian government, courts have been reluctant to ignore sovereign immunities. The case of Russia is not the only contemporary case where it has become difficult to enforce an award against a state that is not willing to cooperate with the international community.
Aquí se aprobó, ¿qué año fue eso? La apertura petrolera, la entrega del país, pues. ¿Cuánto nos costó recuperar la independencia? Ahí está la faja del Orinoco. Solo un gobierno independiente, solo una república independiente pudo haber logrado lo que logró esta república, este gobierno y este pueblo, recuperar la faja petrolífera del Orinoco de la mano de las grandes transnacionales y del imperialismo. Ahí está el petróleo.
In 2007, Hugo Chávez Frías forced 35 oil companies to renegotiate their deals with the government of Venezuela. From that point on, PDVSA, the state-owned company, had to have a 51% participation in any project involving foreign companies. Out of the 35 existing concession agreements, 2 ended up in litigation. ConocoPhillips and ExxonMobil initiated arbitration proceedings against Venezuela. Venezuela had ratified the Exit Convention and signed several bilateral investment treaties with Western nations when it opened its energy sector in the early 1990s. Both ConocoPhillips and ExxonMobil used the bilateral investment treaty between the Netherlands and Venezuela to initiate the proceedings. Venezuela lost in both cases, although it was successful in lowering substantially the amount requested by the oil companies. Just like in the case of Yukos, the companies have had difficulties in having their awards recognized in different jurisdictions. The main difficulty lies on the fact that in most jurisdictions, foreign states and their assets have immunity from litigation. Although there are exceptions, courts have been reluctant to interpret those exceptions too broadly. As you can see, international arbitration is as old as international commerce. And it has been a dispute resolution mechanism to resolve international disputes for many decades. It is by far the most used method to resolve international business disputes today. And it is key to understand its implications if any company is willing to do business abroad, either with states or governments or other foreign business partners. I hope that you have enjoyed the presentation, and I look forward to meeting you in class.